his fate later today on whether the Senate will adopt his impeachment by the Kiambu County Assembly. Waititu has had his day before the Senate Tuesday, expressing a need for the House to give him an opportunity to finish his term as he defended himself against accusations of gross misconduct in office. The governor is among 3 serving heads of county governments that are currently in court over corruption charges and abuse of office. Lawyers presented their statements before the House earlier this morning before the session was adjourned to allow the Speaker to give a ruling on some proposals they had made. Our reporter Leila Mohammed has been following the proceedings and brings us up to date. Leila, when can we expect the decision from the Senate?
Well, Olive, that decision was made at around 11 a.m. when the Senate Speaker came back into the chambers and gave his ruling, stating that he will not allow the new evidence to be introduced at this particular level of where the impeachment proceedings are going on. So that ruling is basing the fact that now the lawyers are being restricted basically to what the County Assembly had presented before the Senate, and basically that is what they are arguing against. They've given various reasons, stating that Ferdinand Waititu was expected to give his deliberations within 3 days on the 25th of January by 5 p.m. He says because a court order restricts him from going into his offices, he wasn't able to get the material that he needed to be able to come up with a defense solid enough to present before the Senate by that predicted time. However, he presented his papers on the 27th, which is the day after, within the confines of the law. So the Speaker now says that those deliberations should continue. Now his lawyers who have begun his defense are now arguing that Senate has no jurisdiction to listen to this matter, considering that the Governor Waititu is already in court on corruption charges, and they say that would be dangling in between the issue of sub judice and talking about matters of double standards, him being going under the court process literally twice. They are also saying that the governor has not undergone any issues in terms of gross misconduct that are gross enough for him to undergo such cases. They also say that the various cases that have set precedent before this one, the 7 that have appeared since the 2013 elections, have all allowed the people who are presenting the case for those who are accused to be able to bring in the evidence. But now that that has been thrown out, they have 2.5 hours from around 12:30 this afternoon to be able to present their case. Remember, they had gazetted only 2 days for this impeachment process to be able to be listened and heard, and for the Senate to make a decision on whether Governor Ferdinand Waititu will continue being in office or will leave office in regards to his impeachment on December 19th, 2019. Part of the deliberations at the floor of the County Assembly on that particular day is what his lawyers wanted to be debated today and presented as part of his case. He says that 2 of the people who are there on that particular day are giving a different account in terms of the numbers and how many people were actually there. So the legality of the whole process was what Ferdinand Waititu was thinking that would be based on his defense as he hangs on to dear life in this particular first term of office as governor. So basically, let us listen in to what was happening between 9 a.m. and 11 when the Assembly went for a recess before they came back to give that decision.
Mr. Speaker, when the governor was served with the invitation to appear on the 22nd of January 2020, he had 3 days to put together his evidence. In doing so, Mr. Speaker, he needed access to his office, which at the time was a challenge, owing to a subsisting injunction. Honorable Speaker, to enable the governor substantively respond to the issues in the invitation to appear, he needed to consult with technical persons within the county government who would then provide him with the material necessary to respond substantively to the issues in the invitation to appear.
It is very clear from the submissions that you have had that the governor is not asking to produce evidence about the allegations on his conduct. You've been told that the evidence is with regard to the logs and attendances at the county assembly. It is therefore clear that the governor has no intention of tabling any evidence with regard to the allegations.
Mr. Speaker, we accordingly urge you very respectfully